Hi my friends, welcome back to my channel, The Revision Desk. In this channel, we will be discussing a lot about several topics which comes in the competitive exams. It includes most of my explanation, my experiences, as well as clarity regarding several topics which are valuable for your preparation for any government or competitive exams. Okay, it includes NCERTs, current affairs, CSAT questions, and much more. So, let's dive into today's topic. In the last video, I have discussed regarding the philosophy of the Constitution. In this video, I am going to what I understood from my basic class of Constitution of India. Okay, so I am also on the journey in this competitive exam. So, I started learning the political science. So Constitution of India is one of the important and major topics to be covered, right? Because Constitution is the one which defines everything in the country. So what is this Constitution? It is Constitution. Yesterday we have seen this. It is a set of rules, regulations of the country, and we also seen that it is the political as well as the social constitution. Okay, so sorry, social document. It is like we have seen there's a basic set of rules that governs the certain aspects of citizens of any country. It is a political document as well as a social document. It is also a legal document. Okay, and why so political document? Because it gives fundamental rights, one of the features. Then it gives socio-economic rights, and it is enforced by law. Therefore, it has these features of political, social, and legal. It ensures equality of all by promoting the egalitarian principle. Okay, then its legal status is binding in nature. It's binding both on the government as well as on the people. Okay, then Constitution tells us what the government can do. Okay, what the government can do, and the guardian of the Constitution is a jurisdiction. Okay, constitutional bodies can be created from the Constitution. They derive their powers from the Constitution, and our Constitution has 25 parts. Then, with amendments, initially there was on 22. With amendments, they became 25. Though the Constitution can be amended, it to the Parliament, they cannot totally change the entire structure of the Constitution. Okay, few important judgments which proved this, which gave that Parliament cannot totally change the Constitution are one Puttaswamy judgment, okay, and also Kesavananda Bharati judgment. See, why these judgments are very important. These are landmark judgments which helps us to understand. What they help us understand in the Puttaswamy judgment case, there is a change of law. Here we understood that the law which is kept depends upon the interpretation of the court. So then the Supreme Court gives the interpretation to the various provisions of the Constitution. And in the case of Bharati judgment, we've seen that the Parliament can amend the Constitution, but it cannot totally rewrite the Constitution. It cannot change the total nature of the Constitution. Then, one question to think: how has the Constitution created the Parliament, or did the Parliament make the Constitution? Then, we get this one more point of thought. An institution which was created by the Constitution cannot in its power subvert or change the Constitution. It means if Parliament is from the Constitution, if it got its powers from the Constitution, it cannot totally change the base of the Constitution. Okay, therefore Constitution has higher power compared to the Parliament. Then, we need to understand that if there is any confusion in the terms of discharge of duty or between the who has to do which, like between the Parliament and the government, if there is a confusion of their powers, so judiciary decides who can do what, and the Constitution empowered the courts to decide or adjudicate any disputes. Okay, Constitution has given vast powers of judicial review to Supreme Court. You might have heard about the term interpretation. What is interpretation? It is a doubt. Whenever there is a doubt or confusion, the courts try to interpret, means they try to understand the situation and provide the better meaning to it. And any changes done which we have to amend based upon that meaning, it is taken up by the parliament. And interpretation can be for the constitutional remedies as well. Okay, in India we have an integrated judiciary, that's Supreme Court, High Court, District and lower courts. Other than fundamental rights in the constitution, we have certain legal rights and constitutional rights also. They are not of fundamental rights, but they are part of the constitutional rights. For example, right to property. Once upon a time it was fundamental right, but now it is a constitutional right, but not a fundamental right. Generally, every person will have a natural right, like which is given by nature, like live with dignity, live with morality. They have constitutional right given by their own constitution, as well as a legal right given by the law. Okay, the laws made by the state legislature are known as act. They give the rights to the people, and the rights given by the constitution is called constitutional rights. That's the basic understanding. Okay, then these rights are created by the constitution, and one of the rights is the fundamental rights for the people of India. So what can we understand from this? Fundamental rights given in the constitution are constitutional rights, but all constitutional rights are not fundamental rights. And rights created under the legislation is called statutory rights. What is statute? Statute means law or rule. Okay, and institutions created by the constitution who derive the power from the constitution are called as constitutional bodies. For example, we have CAG, Election Commission of India, and then UPSC, etc. Then we need to understand that the parliament has the law-making power as well as power to amend the constitution. The power to amend the constitution is from Article 368. It has the constituent power, and the process of amendment has different stages or different procedures, and for different matters of the constitution, different type of majorities are needed in the process of amendment between the Lok Sabha and the Rajya Sabha. So the need for majority differs for several cases of the constitution. It is not same. Okay. Then we need to understand one more part. See, I know you may be thinking why there is no flow. It is all what I've understood in my notes. So it's like a discussion where it's open for you to comment and correct me if it's interesting, and if it's adding value to your learning, you can subscribe. Is there any difference between the amendment power of the constitution and the law-making power of the parliament, or are they both same? Is there any difference between the amendment power of the constitution and the law-making power of the parliament, or are they both same? This is the case of Ananda Bharati case. Okay, so here they are asking, are we making law while we are amending the constitution? That is the base question. The court said no. Both are different powers. Law-making power is different. Amendment of the constitution is different. Okay, both are different. So the case bifurcates the two powers of the parliament. It bifurcates clearly, and also means power. It gives the power to amend the constitution under Article 368, which is a constituent power. Okay, therefore the assembly which proposes the changes in the constitution is called constituent assembly, and the assembly which makes the laws or which pass the act, it's called a parliament or general assembly, right? So whenever they say constituent assembly, it means that assembly created for that purpose of having amendments in the constitution. The right of bringing changes in the constitution is given to the parliament under Article 368. Okay, so there's one more thing to understand. In any situation, if the parliament passes any law or makes any changes which affects the basic structure of the constitution, our structure of constitution is discussed in the last video, right? If that is disturbed, the Supreme Court can declare that law or that act as unconstitutional. The Supreme Court will strike it off. That power is there because Supreme Court is the guardian of the Constitution. Then, if we see a general timeline, okay, we got independence in the year 1947, right? 15th August 1947. Then Constituent Assembly was formed on 9th December 1946, 6 months, 7 months before. Then Constitution was framed and adopted in the year 1949. It was adopted on 26 November 1949. So 26 November is called as Constitution Day. Then it came into effect on 26 January 1950, which is a Republic Day, right? Then if you see, there is a gap between the day of independence, that 15th August 1947, to Republic Day, 26 January 1950. So who was governing? What was governing? Which act was governing the entire country? So our country was working and was governed by the India Independence Act 1947. Okay, so this is the, you can say, the how the Constitution, what the basic understanding of the Constitution and its drafting thing. Now let us see the historical backdrop of the Constitution. Here I am just giving a small hint that historical backdrop, we have to see the role of East India Company as well as the role of the sovereign, that is the Queen's Proclamation Act 1858. There are two developmental phases. Part 1 is the East India Company from 1773 to 1858. Then we have Crown's rule from 1858 to 1947. We'll take up this discussion in the next video. Okay, so I hope you are finding this discussion useful. It's a kind of exchange of what I have learned, a platform to share with people to discuss. So you can comment, subscribe, share my channel, and give your views and your suggestions as well to improve further. This is just starting. Many things are on the way. Stay tuned, and do also tune to the current affairs discussion which I have on my channel. Thank you.